The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon. Thank you for joining me virtually here. We have a great group that's gathered. My name is Laura Genovich. I'm a partner at Foster, Swift, Collins & Smith in Grand Rapids, Michigan. My practice involves representing creditors in consumer and business bankruptcy cases and also handling collections and workouts outside of bankruptcy. And I also serve as a Chapter 7 and a Chapter 12 bankruptcy trustee here in the Western District of Michigan. This seminar, as you know, is about the top 10 mistakes that banks and lenders make in consumer bankruptcy cases. So we're focusing on consumer cases rather than business cases. We're going to be talking about the issues that arise in what you might call the average Joe cases, the people who have filed bankruptcy due to things like credit card debt, job loss, medical debt, divorce, and those kinds of things, rather than the major Chapter 11 bankruptcy filings that often grab the headlines. And the reason we're focusing on consumer cases is because, frankly, that's what most of your encounters with bankruptcies are going to be. With the Great Recession over the last few years, there's obviously been a huge increase in bankruptcy filings across the board, and there's still a high number of bankruptcies. Here in the Western District of Michigan, which basically comprises the state line all the way up to about Mackinac City West, Lansing's kind of the border, and then the Upper Peninsula of Michigan. In the Western District in 2014, there were more than 7,000 Chapter 7 filings, and of those, only 159 were business cases, so the rest were consumer cases. Chapter 13 cases, we had about 1,400 cases, and all of those are consumer cases. In terms of Chapter 11s, which are your quote-unquote big business cases, there were only 39 of those cases in the Western District of Michigan last year. So although, like I said, those might be the ones that get the headlines, the likelihood is that the bankruptcy cases that are actually going to come across your desk are going to be consumer cases. And those present some unique issues for banks and other lenders. Some of the issues that you might encounter include mortgage or auto loan reaffirmations, foreclosures, and surrenders. And in some cases, you might find, if you work at a bank or a credit union or an auto lender, that you're actually the subject of an action being brought by either the debtor or the bankruptcy trustee, which can obviously raise some challenges for you. So it's important for banks and lenders to understand their rights and obligations in these consumer bankruptcy cases. A lot of you might be familiar already with the bankruptcy process, but I'm going to do a brief overview of some of the basics that are going to be relevant for what we discussed today. The first is just a quick overview of the types of consumer bankruptcy cases. You've got your Chapter 7 cases, which, as we saw, are the most common, and that's a liquidation bankruptcy. In that case, an individual debtor can exempt or keep certain property, a reasonable amount of furnishings, a vehicle of a certain value. You know, they're not going to keep an unencumbered $30,000 car, but a vehicle of a certain reasonable value can be kept. Retirement accounts are largely protected, wedding rings up to a certain value, things like that. But if the debtor has property worth more than what's allowed, what they're allowed to exempt under the Bankruptcy Code or under certain state exemption laws, then that additional value is going to be liquidated by the bankruptcy trustee, and that money is going to be used to pay unsecured creditors. So it's liquidated, that's why we refer to it as a liquidation bankruptcy. The trustee can also generate funds to pay creditors by unwinding some pre-bankruptcy transfers. And typically the ones that you're going to see are preference actions, where the debtor preferred some creditors over the other by paying them and not others before the bankruptcy case. The kinds of preferences that the trustee will be able to avoid are not your typical mortgage or car loan payments, but more like when they pay a big amount of money on one credit card, or they repay that $10,000 loan to grandma when they're not paying their other bills. The trustee can also avoid fraudulent transfers where the debtor has given away property without receiving anything in exchange. So those kinds of things, the trustee can pull that back into what we call the bankruptcy estate and use those funds to pay creditors as well. Now, to file a Chapter 7 case as a consumer, where your debts are not business debts, but rather the ordinary personal family debts that consumers have, they have to meet certain income requirements. And in 2005, Congress made things a little bit more difficult and imposed what we colloquially call the means test, which requires them to prove certain income and expense requirements to be eligible to file a Chapter 7 case. The other major type of consumer bankruptcy case is a Chapter 13 case, and that's a reorganization plan for individuals. Business can't file Chapter 13. You have to be a human being. And you also have to have regular income. So this is not going to be an option for the unemployed debtor generally. There's also some debt limits. You're only going to be in Chapter 13 if your unsecured debts are less than the amount you see on the screen there, $383,000 roughly, and your secured debts are less than roughly $1.1 million. If you're an individual and your debts are higher than that, you're actually going to wind up in a Chapter 11 case, which are typically for the big businesses, but also can be for individuals with huge debts. In a Chapter 13 case, the debtor is going to propose a plan to repay creditors over either 3 to 5 years. And sometimes that is a plan to pay 100% of the debt, and sometimes it's a plan to pay less than 100% of the debt. If it's going to be less than 100% of the debt, then the debtor must commit all of their disposable income for that 3 to 5 year period to the plan. So all of their, and there's a lengthy calculation for how to determine what's disposable income, but certainly you got to figure your tax refund and a lot of your wages and things like that are getting committed to the plan for that commitment period. Then if there's a balance on those debts after that period of time and after they successfully complete the plan, then that balance is going to be discharged. And discharge is a term of art in bankruptcy, but roughly means it gets wiped out and the person is no longer personally obligated for that amount of the debt. So that's a quick overview of the two types of bankruptcy cases we're going to be talking about today. And another quick review before we dive into the top 10 mistakes is just a review of what a secured versus an unsecured claim is, because we talk about that a lot. So a secured claim is a debt that is secured by a lien on real or personal property. So it might be a mortgage on the debtor's house, it might be a lien on the debtor's vehicle, perhaps a lien on the debtor's boat. An unsecured claim, conversely, is a debt that is not secured by a lien on any real or personal property. Now, a lien really makes the property liable for the debt. So a lien is typically not discharged in bankruptcy, meaning that the lien is going to survive the bankruptcy even if the debtor gets a discharge, and even if that underlying debt would be dischargeable. So a way to look at that is that the property remains liable for the debt even if the borrower does not. That means that you won't be able to sue the debtor for a deficiency if you are able to later sell the property and pay off the mortgage and there's some amount left over. You can't sue the debtor for that deficiency because they're not personally obligated anymore. They get a discharge as to that personal obligation, but the property remains liable and the lien survives the bankruptcy in most cases. Now, all of that said, a secured claim can sometimes be modified or challenged in bankruptcy, which is among the things that we will be discussing today. All right, as promised, top 10 mistakes that banks and lenders make in consumer bankruptcy cases. Here's the overview, and then we'll go into each one. Number 1, violating the automatic stay. Number 2, waiting too long to seek relief from the stay. 3, failing to thoroughly review the Chapter 13 plan. 4, failing to file a proof of claim in a Chapter 13 case. 5, failing to file a proof of claim in a Chapter 7 case. 6, failing to correct defects or errors before the bankruptcy is filed. 7, trying to correct those defects and errors after the bankruptcy is filed. 8, failing to object to the discharge in appropriate cases. 9, missing opportunities to work with the trustee. And 10, not consulting with knowledgeable bankruptcy counsel. So starting with the first, violating the automatic stay, the way I always describe it to my creditor clients is that the automatic stay is a big stop sign. It means all of your collections efforts, at least temporarily, have to come to a halt as soon as you receive that notice that someone has filed bankruptcy. Now here's a few excerpts from the Bankruptcy Code, which is why it's so long and in small print. Generally, the bankruptcy filing operates as a stay of the following types of actions, among other things. So these are the big ones. It's going to stop your lawsuits against the debtor. So there's your language there, the commencement or continuation of a judicial, administrative, or other action or proceeding against the debtor that could have been commenced before the commencement of the bankruptcy case. So we're talking about lawsuits for pre-bankruptcy debts or claims. It's also going to stay actions against the debtor's property. So that's the enforcement of a judgment against property or any act to obtain possession of property of the estate or property or exercise control over property of the estate, so your foreclosures and repossessions. It's going to be a stay against creating liens, any act to create, perfect, or enforce a lien against property of the estate, and any act to create, perfect, or enforce against property of the debtor. There's a distinction between what's property of the estate and property of the debtor, but suffice it for our purposes today to say you better better not be creating liens without getting permission from the bankruptcy court first. It's also going to stay collection activities, so your demand letters and any act to collect or recover against the debtor a pre-bankruptcy claim. So to summarize those, what this means for secured lenders is that unless you first get relief from the automatic stay from the bankruptcy court, so unless you first get that court order in hand, you cannot foreclose on a mortgage on the debtor's real property. You cannot repossess the debtor's vehicle, boat, or other collateral. You cannot sue the debtor for any deficiency owed. And you cannot send demands for payment to the debtor or call them up and tell them that they better pay or you're going to sue them or take any of those other kinds of collection actions. If you do any of those things while the automatic stay is in effect, as we'll see in the next slide here, and I'll jump here and then come back, there are penalties for violating the automatic stay. And the code provides that an individual injured by a willful violation of a stay shall recover actual damages, including costs and attorney fees, and in appropriate circumstances may recover punitive damages, which are designed to punish the person who did it. So they don't have to relate to actual damages or costs incurred by the debtor, but they are meant to punish you. So if a court finds a creditor willfully violating the stay under appropriate circumstances, the court will enter an award of damages designed to punish, and that can obviously be a lot of money. Jumping back to this slide for a moment, that doesn't mean you can never do any of these things. It doesn't mean you can never have a foreclosure when there's a bankruptcy. It just means you have to get relief from the automatic stay first. And the standard for getting relief from the stay or permission to take these actions, there's two big ones. One is for cause, such as lack of adequate protection of the lender's interest. A lien or a mortgage is a property interest. You, the lender, have an interest in that property. And if that interest is not adequately protected, that's going to give you a cause, a good reason to go to court and say, I need to go get possession of this property. For example, the debtor doesn't have it insured. It's a car. The debtor's driving around with no insurance, or it's a house and it's not insured. I want to go get my collateral before the value all goes away. And there's good reason, there's cause for me to get relief from the state to do that. The other reason is there's no equity in the property, so the value is less than the amount of the debt, and the property is not necessary for an effective reorganization. Recall that in a Chapter 13, the debtor is reorganizing their debt. So sometimes the debtor may need whatever that property is, the house or the car, for an effective reorganization. In a Chapter 7, the debtor does not have that argument because they are not reorganizing anything. It's a liquidation case. So the debtor cannot ever say in a Chapter 7 case that the property is necessary for an effective reorganization. So if you're in a Chapter 7 and you've got a situation with no equity and you're not able to reach an agreement with the debtor to reaffirm or redeem that property, then you are going to have a good basis for getting relief from the automatic stay. All right, here's a first cautionary tale. It's easy to say don't sue the debtor, don't foreclose without permission, but sometimes violations of the stay are not so obvious. So this is a case out of Ohio from a few years ago. The debtor had a home mortgage from the bank, and it also required that she have a checking account with the bank from which her mortgage payment was deducted. The computer at the bank automatically swept the account on the 4th day of each month, and then if it didn't have enough money, it kept sweeping the account until it found funds to pay the mortgage. Well, the debtor filed bankruptcy and properly listed the bank, and the bank received notice of it, but the bank didn't stop that computer automatic withdrawal. The debtor then put money into her checking account, which she did not plan to use for her mortgage, and she wrote some checks, but the bank automatically, through its computer program, withdrew that amount and applied it to her mortgage balance, and that caused the debtor's other checks that she had written to bounce. So there was some back and forth, and the debtor went into the bank, and they weren't very helpful at first, and finally her attorney got involved, and it got moved higher up in the bank, and the bank 13 days later reversed that withdrawal. By that time, the debtor was frustrated and went to the bankruptcy court saying, hey, they violated the automatic stay. And the court held that the bank had willfully violated the automatic stay, even though it was an automatic withdrawal through a computer program. Because the testimony was that that was the bank's process, that they didn't stop that automatic withdrawal even when they got the bankruptcy notice. In that particular case, the court did not impose punitive damages. It awarded actual damages, which were limited to the fees that she incurred for the bounced checks. But nonetheless, it serves as a cautionary tale that you really have to think about all of the ways your system might be trying to collect debts, even short of an actual active foreclosure or lawsuit. All right, related to the first, we talked about not violating the stay and seeking relief. Sometimes lenders make a mistake by not seeking that relief fast enough, and it hurts them. So a secured lender, as we discussed, is often entitled to get that relief from the automatic stay, especially if you've got a debtor who's not paying and you've got property that's not insured. That automatic stay, the big stop sign, stays in effect until the property is no longer property of the estate, which can be sometime after the debtor gets their discharge. So sometimes banks or lenders decide to just wait it out, wait for the bankruptcy case to close, and for that property to no longer be property of the estate, so that they don't have to file a motion with the court. And they might believe that that's cheaper or easier because they don't have to hire a lawyer. Well, the problem with that approach, or the risk to that approach, is that the value of your collateral is likely going to decline. A Chapter 7 bankruptcy case might close within a few months, or it might be open for years. And with motor vehicles in particular, you know the value is going down every day that it's on the road. And if it's not insured, whether that's real estate or personal property, the collateral could disappear altogether. So if you haven't got relief from the stay yet and you have reason to believe that the property is not insured, you should also consider obtaining force-placed insurance in the interim to protect that interest, and then quickly get relief from the stay if your intention is to foreclose on the real estate or to repossess the personal property. All right, sometimes the debtor might be keeping the collateral and continuing their payments, and one example of that might be in a Chapter 13 case. So as a secured creditor in a Chapter 13 case, you're going to get a copy of the debtor's proposed plan of reorganization, and you want to carefully review that Chapter 13 plan and not just toss it to the side of your desk, because if the debtor's not treating you right and you don't object, you might get stuck with the wrong treatment. Now, generally, treatment of secured creditors in Chapter 13 is outlined here. Either the creditor is going to be okay with the plan and they accept whatever that treatment is. It's going to be okay if the creditor is keeping its lien and is going to be paid the full amount of its secured claim in equal monthly payments under the plan. It might be that the debtor is going to surrender the collateral and will say that in the plan so the lender then knows what's going to happen with it. And it might be that the debtor is proposing to pay the secured creditor outside the plan, meaning they're going to pay the debtor, pay the creditor directly rather than having the payments go through a trustee. Typically in a Chapter 13 case, you have a trustee appointment whose job it is to collect the payments and disperse them to creditors. So the debtor is just making one monthly payment. All the funds are getting funneled through the trustee. The trustee can make sure that all the claims are properly paid. And then if the debtor is not keeping up on those payments, the Chapter 13 trustee has the burden of going to court and seeking to have the case dismissed because the debtor is not following through on their obligations. So a risk to getting paid outside the plan is if you've got a debtor who's not good at making their payments, you're losing the protection of having the Chapter 13 trustee collect those payments. And then if you're not getting paid, you as the creditor have to go to court to seek that dismissal or relief from the stay or other remedy rather than having a Chapter 13 trustee there to do the work for you. So sometimes a secured creditor's rights can be modified in a Chapter 13 case. And Chapter 13 of the Bankruptcy Code provides the plan may modify the rights of holders of secured claims other than a claim secured only by a security interest in real property that is the debtor's principal residence, or of holders of unsecured claim, or leave unaffected the rights of holders of any class of claims. So what this means is that the Chapter 13 plan cannot change the terms of a mortgage on the debtor's primary residence. So the debtor can't propose, for example, to change the interest rate on their home mortgage for their primary residence. So mortgage lenders obviously need to review the plan to make sure that the plan's not trying to modify a residential mortgage. But note that if you have a second mortgage that's completely unsecured, it's completely underwater, there's no value in the property for that second mortgage to attach to, then that mortgage can be modified by the plan because it's no longer secured by the primary residence if there's no equity in the property to which that mortgage can attach. And sometimes you'll hear this called lien stripping. Another phrase you're going to hear sometimes when talking about Chapter 13 is cram down. We have all these neat terms of art for ways that debtors can modify rights in bankruptcy. So if you have a secured claim, that claim can actually be reduced. If it's not that we're not dealing with the principal residence now, but the amount of the secured claim can be reduced to the value of the collateral. So if you've got a loan that was $50,000 and the property is now only worth $30,000, then the Chapter 13 plan can treat only $30,000 of that as secured, meaning that they only have to make the full payments in equal monthly installments for the $30,000 amount. And the balance, the other $20,000, they can treat as an unsecured claim, and it might not get paid in full. Depending on the Chapter 13 plan, it might get paid 100% or it might get paid 10%. Now, there's an important exception to this. Call it, again, colloquially, the 910-day rule. Secured creditors with a purchase money security interest in a vehicle that was acquired by a debtor for personal use, so it's not their business car, this is their personal vehicle, within 910 days before the bankruptcy filing are protected from being crammed down. So you can't bifurcate that claim into a secured portion and an unsecured portion. And Congress did this to prevent debtors from running out and buying a car and then immediately filing bankruptcy and saying, oh, I only have to pay a secured claim, the part that's actually the value of the car. Because as we know, cars lose value very quickly. So if you are in the business of making auto loans, you should be very aware of this rule, and you should be looking for it when you receive that Chapter 13 plan, because we see it a lot for auto lender clients where debtors just flagrantly try to cram down debts that are not subject to being crammed down because of that provision. If the debtor is proposing an unlawful modification, whether they're trying to cram down an auto loan that's protected by the 910-day rule, or they're trying to modify a mortgage secured by a principal residence, you need to file an objection to the Chapter 13 plan with the court, and you have to do that before the deadline established by the court. If you fail to object and that plan is confirmed, you're going to wind up being stuck with the treatment in the plan. Like it or not, it's treated as basically a new contract between you and the debtor. So it's very important to look at that plan when you receive it. Another Chapter 13 issue that comes up is failing to file a proof of claim in a Chapter 13 case. A proof of claim is exactly what it sounds like. It's a form that requires the creditor to prove they have a claim. So it's going to set forth the amount and the nature of the creditor's claim, including whether it's a secured claim or an unsecured claim, identify the collateral, and provide some proof supporting documentation for the claim. So you're typically going to attach promissory note, mortgage or other security documents, statement of account showing what the balance is at that time, anything that's available to substantiate the amount and the nature of that claim. Sometimes, because you have to realize the debtor has also filed schedules saying what their debts are and who's a secured creditor. So the debtor may have correctly listed that you're a secured creditor and they've got the collateral right and they've even got the balance right. So secured creditor might say, all right, well, I'm not going to bother filing a proof of claim because the debtor's already got me correctly described in the bankruptcy schedules. But I would urge you to still file a proof of claim. Failing to file a proof of claim doesn't take away your security interest. It doesn't divest you of your secured status. But if you want to get paid through that Chapter 13 plan and you want to be getting distributions, you need to file a proof of claim. Don't rely on the debtor to provide for you in the plan. If you want to ensure that you're going to get paid and ensure you're getting proper treatment, you need to file a proof of claim. You're also sometimes going to file a proof of claim in a Chapter 7 case. Now, Chapter 7 cases can be divided into what we call no asset cases and asset cases. About 90 to 95% of them are what we call no asset cases, meaning that there's no money for the trustee to distribute to unsecured creditors. Asset cases, conversely, are cases in which the trustee will or expects to have funds available to pay unsecured creditors. In every Chapter 7 case, the first notice that comes out says don't file a proof of claim unless the court tells you to. I'm going to talk about an exception to that on the next slide. But first, in an asset case, if the trustee reviews the case, has this what we call the first meeting of creditors, which is sometimes called a 341 meeting. It's named after Section 341 of the Bankruptcy Code. The trustee might say, hey, there's a boat I can sell, or hey, there's some preferences I can avoid. I think I'm going to have money here for creditors. Then the trustee is going to file something with the court that prompts the court to send a notice to all of the people listed in the bankruptcy case, all of the creditors, giving them 90 days to file a proof of claim. It's very important usually for an unsecured creditor to file a proof of claim because that's who the trustee is going to directly pay. But it's also important for a secured creditor to file a proof of claim for a couple of reasons. One is the collateral might be getting sold by the trustee. You might have a situation where there is equity in the property over and above, obviously, the amount of the loan on the property. So the trustee is going to go out and hire a realtor, hire an auction company, and sell the collateral, take the debtor's equity, and use that to pay unsecured creditors. But obviously, your secured claim is going to get paid as well. So it's important to file that proof of claim so that you've got ready and available proof there of the amount of your lien so that that can get paid out of the sale proceeds of that collateral when the trustee sells it. It's also very common, especially with fluctuating property values, to have a claim that is partly secured and partly unsecured. So even though perhaps you're thinking of yourself as a secured creditor, the value of the property may be less than what you'd like it to be, and you may have part of your claim that winds up being unsecured because the value of the property has declined. So in that case, you might have the ability to get paid by the Chapter 7 trustee as an unsecured creditor when there are assets to pay unsecured creditors with. Now, I mentioned there is an exception. Typically, you're not going to have to file a proof of claim in a no asset case. But a secured creditor might still consider filing a proof of claim if they have a purchase money security interest in personal property. So purchase money security interest means the secured creditor provided the financing for the acquisition of the personal property. And there's this kind of little known provision in the Bankruptcy Code that says the debtor shall not retain possession of property in which a creditor has an allowed claim for the purchase price secured in whole or in part by an interest in such personal property, unless the debtor, within 45 days after the first meeting of creditor, reaffirms or redeems the property. Reaffirming the property is where the debtor promises to pay back the debt even though they're not obligated to so that they can keep the property. Redeeming the property is when the debtor makes an offer to basically buy out the creditor's interest for a lump sum of money. I'm not going to go into a lot of detail on those, but if the debtor doesn't do one of those things within 45 days after the first meeting and the creditor has an allowed claim for that purchase money security interest, then the creditor is going to be able to get that property back, kind of short-circuiting the process and get it more quickly than they would otherwise get it if they had to go through the regular relief from stay procedures. But to have that allowed claim, because the language requires an allowed claim, the creditor has to file a proof of claim. So it seems a little funny because the court has just said don't file a proof of claim, but if you want to have an allowed claim for purposes of this section, you have to file a proof of claim, and there's a case that supports that. So that would be a situation in which you would want to file a proof of claim, even though the court's telling you that you don't need to. All right, switching gears a little bit, another mistake is failing to correct defects or errors before the bankruptcy is filed. So you're a mortgage company and you've got a mortgage on the house and you think you're all set. Well, sometimes there can be things wrong with how that mortgage was recorded or how a lien in personal property is perfected that can allow the Chapter 7 trustee to actually set aside your security interest. Chapter 7 trustees are looking for these kinds of things. So they're reviewing all the security documents and looking for the kinds of defects that will allow them to avoid that mortgage and essentially wipe out your interest. Examples in Michigan, I mean, bankruptcy law is federal law, but it applies state law in a lot of contexts. So the Michigan bankruptcy courts have allowed trustees to set aside mortgages where the legal description of platted property has the incorrect lot number. And the reasoning for that is that the Michigan statute for recording documents to perfect an interest in platted property require that you have the correct lot number. So if you're missing a lot number, or it should say lot 6 and it says lot 7, the trustee is actually going to be able to avoid that as basically a hypothetical bona fide purchaser for value. It's under Section 544 of the Bankruptcy Code. Another problem is if the mortgage is recorded in the wrong county. And in my capacity as a trustee, I've had several cases like this, surprising to me, where it's just not recorded in the right place and it has to be recorded in the county where the property is located. Otherwise, it's an unrecorded mortgage, and under that same Section 544, the trustee is going to step into the shoes of a hypothetical bona fide purchaser for value and be able to avoid that mortgage. When the trustee avoids the mortgage, that means you're out of the picture, and basically the trustee is holding the mortgage now. Another example is where the secured lender's name is not on the vehicle title, and importantly was also not on the RD 108 form that was submitted to the Secretary of State. If the Secretary of State made the mistake, then you've got a defense as the secured creditor, but if it never even got submitted to the Secretary of State, you've got an unperfected lien and you've got a problem. So if these mistakes come to your attention and there's no bankruptcy case, it's best to correct them when they're caught. Mistakes do not get better with age or time. If you correct the mistake and you record the lien, or get it recorded in the right county, get the name put on the vehicle title, and if a bankruptcy is filed within 90 days after that, you might still have a problem. It might be seen as a preference. There might still be some avoidance issues. But in advising clients, I'd say it's still better to try and get it fixed because you don't know when that debtor's actually going to file bankruptcy. Sometimes it takes them a while. And also sometimes debtors want the mistakes to be fixed because they want to keep the property. They want to reaffirm it, or they want to in some way keep that, so they don't want the trustee coming in and avoiding the mortgage. And that leads to another cautionary tale I have from a case that I had where the debtor discovered a defect in the mortgage. This was a case where I was the trustee, and the debtor had gone to the lender and said, please reform this mortgage. There's a problem with the legal description that if I'm going to file bankruptcy, the trustee is going to avoid it, and I'd like to keep my house. Months went by, and the lender did not take any action. They did not make any progress with it, so the debtor finally gave up and said, I got to file bankruptcy. I guess, it is what it is. So the debtor filed bankruptcy. Trustee sued the lender to avoid the mortgage. That could have been fixed. The debtor was willing to work, was not rushing to file bankruptcy. If the debtor and the bank had worked together, they could have reformed that mortgage, waited 90 days to file the bankruptcy, and the trustee would not have been able to go in and avoid that mortgage. So if you have that kind of opportunity, you should seize it. The flip side of that is that if the mistake's been made and the bankruptcy case has been filed, your options are limited. And if you try and fix the mistake after the fact without getting appropriate court orders, it can backfire. So examples of that would be the case is filed and you realize your mortgage was not recorded, so you run to the Register of Deeds and record it after the bankruptcy is filed. Not going to protect you and may violate the automatic stay that we talked about earlier. Same with reforming a mortgage without court permission, or filing a UCC financing statement because you realize you didn't file one for that pre-bankruptcy lien. These actions aren't going to protect you, and they might actually get you in some trouble. So a case example of that is where the debtors had refinanced their home mortgage before the bankruptcy, and the mortgage didn't get recorded. So after the bankruptcy filing, the mortgage got recorded, and the trustee sought to avoid it. And the court held that the trustee could avoid the mortgage as a hypothetical bona fide purchaser for value, and the post-bankruptcy recording of the mortgage did not protect the lender in that case. All right, switching gears a bit again, another mistake that comes up is failing to object to the discharge in appropriate cases. So we talked briefly about how the debtor gets a discharge in bankruptcy, meaning that their personal liabilities for certain debts will be wiped out if they successfully complete the obligations of their bankruptcy. Not all debts, though, are going to be discharged. There are exceptions to the discharge. Some of the most common exceptions that are used are listed here. There's no discharge if the debtor obtains money, property, or credit by false pretenses, false representation, or actual fraud other than a statement about the debtor's or an insider's financial condition, or if the debtor uses materially false written statements regarding the debtor's financial condition on which the creditor relied that were made with the intent to deceive. So if you have that kind of situation, it might not be discharged. Also might not be discharged if the debt is for fraud or defalcation while acting in a fiduciary capacity, or if there's embezzlement or larceny. So naughty conduct. And no discharge if the debt is for willful and malicious injury by the debtor to another entity or to the property of another entity. So typically these issues, and looking at whether you're going to have a debt found to be not discharged in bankruptcy, it's going to be important for creditors with unsecured debts because their interest is not protected by a lien. But it can be raised by a creditor who's partially unsecured or somebody who was a secured creditor but their collateral was destroyed by the debtor or otherwise lost. So an example from a case where I represented an auto lender, one of the more interesting cases I've worked on, and it's been resolved and it's been decided and it's done now. The creditor had properly perfected a purchase money security interest in the debtor's vehicle. The debtor used a very elaborate fraudulent scheme to transfer title to the vehicle and remove the lien without actually having made a single car payment. It involved, among other things, a forged lien release letter and a forged signature on the title of a name of somebody who had never even worked for the creditor lender company. So this resulted in a loss of the collateral collateral, the vehicle, to a bona fide purchaser for value. So somebody went and bought that car, paid good value for it, had no idea of anything about this fraudulent scheme, and our client was left with a debt and no longer any collateral through no fault of its own. So we filed a non-dischargeability action, which is an adversary proceeding, also called a lawsuit, in the bankruptcy court, and won on summary judgment and was able to oppose the discharge. So even though the debtor had filed bankruptcy, she remains on the hook for the debt that she owes to the auto lender because of the willful and malicious injury that she caused to our client's collateral. So if you've got a situation either where you've got a partially unsecured claim, or if you've got a debtor who you think has engaged in some kind of wrongdoing, and you'll typically know what those cases are, it's worth having an attorney take a look at whether you may have a non-dischargeability action. It's important that you do that quickly. There's a short deadline for filing a complaint for non-dischargeability under those 3 sections that we talked about. A complaint to determine the dischargeability of a debt under 523C has to be filed no later than 60 days after the first date set for the meeting of creditors under Section 341. So 60 days is a pretty short timeline. I mean, typically when we think of statute of limitations, we talk in years, not days. So that's a short time frame. And it's set from the first date set for the 341 meeting. It's not uncommon for 341 meetings to get rescheduled or adjourned. You don't want to base your deadline on that rescheduled date. You've got to look at the very first date set, and that's going to be on the notice that you receive in the mail when you get notice of the bankruptcy. That first piece of paper that you get in a bankruptcy is going to be the notice of the meeting of creditors. So that's the date that you're going to want to be looking at, not any rescheduled date that the court later sets. So you want to quickly evaluate any potential non-dischargeability claims as soon as you get that notice. So that's another sheet you don't want to set to the side of your desk. Another mistake is missing opportunities to work with that big bad Chapter 7 trustee. As discussed, a Chapter 7 trustee can sometimes be adverse to a secured creditor. We've talked about avoiding mortgages and avoiding liens and going after preferences and things like that. But secured creditors and Chapter 7 trustees can also work together and can provide for a quick, efficient administration of property. So there's a couple of things that can happen when a debtor owns real estate that's subject to a mortgage. If there's equity in the property, then the trustee might get court permission to sell the property, keep the equity for the benefit of the creditors, and still pay the mortgage in full, and everybody's happy. More often, there's not equity in the property, as we all know, so often the bank will be getting relief from the automatic stay and proceeding with foreclosure. But there's another option out there, what we kind of call a carve-out agreement, where even if there's no equity, the bank can allow, if it wants to, allow the trustee with court approval to sell the property in exchange for sharing a portion of the sale proceeds with the bankruptcy estate for the benefit of the unsecured creditors. So there's no equity, there's no absolute right for the trustee to go out and liquidate this property, but the bank is agreeing to give up part of its share of the sale proceeds to the trustee for there to be a bankruptcy sale. Now, why on earth would you want to do that? Frankly, if you don't do that, right, you've got to go get relief from the automatic stay that we talked about, and then you have to proceed with foreclosure under state law, which can take months, and you've got redemption period and different kinds of challenges there. With a carve-out, the trustee can obtain a court order for a sale often as quickly as within 30 days if you've got a buyer lined up, and convey the property via a trustee's deed, which is essentially like a quitclaim deed. It's much faster, and there's no redemption period, and the trustee might even help pay some of the expenses of preserving the property during the marketing and sales process. And the trustee likely will be the one to prepare all the motions with the court, the deed, and handle all the logistics. So the bank often is able to sit back and let the trustee do that, and in exchange, the bank is willing to give some percentage, whatever is negotiated, whether it's 10% or 20% of the sale price to the trustee for having done that. So it can really be a win-win opportunity if you've got property that you want to unload quickly. All right, number 10 on our list of top 10 mistakes is not consulting with knowledgeable bankruptcy counsel. Obviously, there's a lot of complex issues that can arise, and for some things, you might be able to handle it on your own, frankly, because even though a company needs an attorney to appear in court, the Bankruptcy Code will allow a company to file a proof of claim and appear at the meeting of creditors without an attorney. So if it's a very straightforward case, you can file a proof of claim without the benefit of legal advice. it's still a good idea, I think, to get it, especially if you have any question about the nature of the claim, how you want to substantiate a claim, or if you've got something unusual in the case. But you're not required to have an attorney file a proof of claim. You're also not required to appear at the meeting of creditors. The meeting of creditors is an opportunity to examine the debtor about their financial affairs. It can be beneficial to have the creditor or creditor's attorney appear, especially if there are questions about where the property is located, where the collateral is located, what condition the collateral is in, whether the collateral is insured, and what the debtor's intentions are with respect to that collateral. But you're not required to appear at that meeting, and your rights are not impaired in any way by failing to appear at that meeting. Now, a company does need an attorney to file pleadings or motions with the court. So to file a motion for relief from the stay, to file a non-dischargeability action, to object to a Chapter 13 plan, or to file any kind of other motion for relief from the court. You can't do that as a mortgage loan officer. You've got to have an attorney do that. And you also may benefit from using a knowledgeable attorney to negotiate with the debtor or the trustee. For example, in a situation where you get a demand letter from the trustee saying, hey, your mortgage is not recorded and I plan to sue you and avoid that. That's a good time to call your lawyer. But also evaluating whether it's worthwhile to consider a carve-out agreement or whether it's best for the bank in that circumstance to just proceed with getting relief from the stay and pursuing a foreclosure. Those are the kind of situations where you can really benefit from using an attorney. So certainly getting that notice of a consumer bankruptcy filing can present challenges, but hopefully these tips will help you better protect your rights and your collateral. And if you do have questions, I put my contact information up here. I encourage you to send me an email. My email address is there. I'll try to get back to you as quickly as I can, or feel free to give me a call. I've also put a link there to my blog, which gives case law updates on cases from Michigan's bankruptcy courts. And you can also look me up on LinkedIn. So thank you again for your time. I appreciate everyone coming today, and I hope you have a great afternoon.